First on 4, a major hurdle cleared this week. A proposed Texas bill that aims to change the death penalty in our state has passed the House.
Now, CBS 4 Sandra Garcia joins us in the studio. And Sandra, this is a step up from a previous Supreme Court ruling that bans the execution of mentally disabled inmates.
That's right. The Supreme Court ruled that mentally unstable inmates were ineligible for the death penalty, but that prohibition did not include those who classified as mentally ill. The difference between the two could mean change in the nation's busiest death penalty state.
This is a problem that prosecutors are facing these days throughout Cameron County and in the state of Texas.
House Bill 1936 aims to ban the execution of mentally ill inmates.
A mentally ill individual simply has some distress or impairment in their life. Could be anxiety, depression, or even coping with grief and loss.
Back in 2002, the Supreme Court issued a landmark ruling that prohibited the death penalty for the mentally disabled.
A person who is mentally unstable or has a mental disability, it's more of a severe interference with a significant life activity, such as going to school or working or communicating and socializing with others.
But the distinction between mentally ill and mentally disabled has been the deciding point in a life or death sentence.
People that are, in one sense commit criminal acts, but in the true sense they're not criminals because they suffer from mental diseases. They're not on medication, or they're on the wrong medication.
If the bill passes in the Texas Senate, the change in death penalty law would push for further inclusion of those struggling with mental illnesses like bipolar disorder and subsequently commit a crime.
It definitely could be an issue where they may not necessarily know right from wrong and can be a danger to self or others.
The bill passed 77 to 66 in the House. It now heads to the Senate committee. In the studio with Complete Valley coverage, Sandra Garcia, CBS 4 Valley at 6.